So we're gonna be live soon, so prepare yourselves. Okay, just some seconds. Okay, we're live now.
Pessoal, boa tarde a todos. Me chamo João Marcos, sou diretor do IBDD e venho aqui juntamente com o Pedro Canelas e o Fernando Bonilha, eu diria, apresentar essa segunda edição do IBDD Sem Fronteiras, agora com essa repaginação e com uma participação direta do Fernando e do Pedro. Hoje, eu diria que talvez esse seja um dos mais relevantes painéis que a gente tenha montado aqui ao longo da história do IBDD, não só pela relevância dos convidados que a gente traz aqui, mas pelo tema. A gente vai falar um pouco sobre os procedimentos não só no Tribunal da FIFA e no Tribunal do CAIS, e vou explicar um pouquinho como a gente sempre faz, na verdade o IBDD Sem Fronteiras nesse formato, na medida em que a gente traz convidados de fora, por mais que o Roberto, o Daniel também sejam brasileiros, aqui nossos nossos parceiros aqui do Brasil, mas a gente, em função também da participação do professor Colucci, nós faremos também o painel em inglês, e daí, ao final de cada bloco, a gente faz uma rápida exposição daquilo que foi falado. Então, vou virar agora para o inglês, para já a gente dar início ao IBDD Sem Fronteiras. And guys, again, we spoke about this previously. I think this is one of the most important opportunities that we have here in Brazil, to have all those big names in the market, like Professor Colucci. And Professor Colucci, I bring something to him in the beginning that for me, Fernando and Pedro, this is a very unique opportunity, not even because of you, Professor Colucci, but also Daniel and Roberto. Me, Pedro, and Fernando, we were students at ISD, and Daniel and Colucci were all of our professors. So I'm going to explain a little bit about the dynamics of our panel. As I said, we're going to hold the discussion in English, and we tried to divide into 3 different blocks, and I'm going to hold the first block, and Fernando is going to hold the second one, and Pedro will catch up the main issues that we spoke in the beginning to bring those final considerations to the end. So, Fernando, I'm going to give the word to you so you can present our guests today, and then we move on with the blocks. So you have all the floor for you, Fernando.
All right. So thanks for that, João. It's always a pleasure to be here with you all, and also a truly honor to have all of you, Professor Michele, which you was one of my professors at ISDE. Professor Barraco, which was one of my professors in my post-graduation that I've done it in the past, and Mr. Daniel. And to our panelists, really, João, no needed any kind of presentation or introduction. So I would like to invite each of you to briefly introduce yourself, tell us a little bit about your background and how you first got involved with sports law and end up being a CAS arbitrator or a FIFA dispute arbitrator, I mean.
So if we can start with Mr. Colucci, that is our international guest, and then we move on to Daniel and then Roberto. Please, Mr. Colucci.
Okay, thank you so much. First of all, thank you so much and congratulations with this beautiful initiative, which gives me the opportunity to see and to talk to friends, dear friends again, from Brazil and beyond. For those who do not know me, I am a lawyer, a sports lawyer, Italian 100%. And as a sports lawyer, I've been practicing sports law since more than 30 years, both in the public and the private sector. In the private sector, for several years, I've been defending clients, clubs, federations, leagues at international level. And I've been working as a judge of the FIFA Dispute Resolution Chamber since day one, since November 2002, 2001 officially, and following the famous Bosman case when the FIFA was obliged to establish this dispute resolution chamber. In the public sector, I've been serving as a civil servant of the European Commission, this European Union institution in Brussels, where I've been working at the legal service, and I've been involved in the sports law, the freedom movement of players at European Union level. And of course, this gave me the opportunity to analyze the football law at international level from a private and a public perspective until now, until the Sereng case, the Sereng judgment that I'm sure you are at least aware of, another important case of the European Court of Justice, which is going to have surely an impact on arbitrations in general and sports arbitration in particular. And I stop it here. Thank you.
Thank you so much, Professor. As I said, it's always a pleasure to have you here with us, joining us today. So I'll give you the word for Daniel. Can be you, Mr. Daniel.
Yes. Fernando, please. Since this is probably one of my last presentations due to my age, please don't call me sir. I'm kidding with João, because I took so long to get to the cast, and now João wants me to retire already. So hold on a little. That being said, João, I'm just making a joke. At least we make things softer after Michele brought a very heavy issue concerning Serraing. It is a pleasure being with you, João, with you, Fernando, and Pedro. And as I said in the backstage before, I think this is a very unique and very important platform that you are building here, bringing and mixing people from all over the world. We have a lot, I mean, really, of very important and experts in Brazil, but it's not very usual to have foreigners, experienced professionals speaking to us here. So my applause to your initiatives and, of course, IBDD. That being said, Michele, it's a pleasure always to be with you personally or online. I always learn much more than I expected. I should know that already. And the same goes to Beto. Barraco is, for me, by far one of the most, if not the most important sports jurist in Brazil nowadays. And I mean that. And the deepness, the commitment of Roberto, as you probably know now, it was rewarded. I'm not sure if rewarded is a good word because it's a lot of work, but to be responsible for one of the most important sources of case law in football law from FIFA. So here again, it's a pleasure. Since I've spoken about everybody, I have less time to speak about me, but let's make it quick. I would suggest you, if you want to address all the questions, some of them, I'll try to sit in the chair of a lawyer, because I've been a lawyer before FIFA and CAS and CONMEBOL and the Brazilian disciplinary courts for the last 23, 24 years. I've been a lawyer of Fluminense, Internacional from Porto Alegre, the Brazilian Tennis Confederation. We still are working for all of these entities. Many players, many agents all over this time. And then since 2021, I am now, I'm occupying. I had a mandate. You're not you're not a CAS arbitrator forever as a profession. You have a mandate, you have a time to be there. So I'm closing the 4th year. It's a very rich experience. It's a very challenging experience because you have to change your, I'm not going to use a word that I don't like that much, but I think it suits this description. It's this mindset, because if you are working as a lawyer, somehow you are more attached to your client, but you're more free in a certain sense. As a judge, as Michele knows, and also Roberto, who joins me in the CAS list as a Brazilian CAS arbitrators, we know that sometimes it's very, very difficult not to be involved by the atmosphere that doesn't have exactly to do with the case. And I mean the behavior of the parties and the lawyers, many things. So I think that both of the activities, to be well accomplished, they require commitment, but I think it's a different position. So in some issues, and I'll tell in advance when I'm speaking as with the lawyer's mind or the arbitrator's mind, and we know that as arbitrators we should refrain from from speaking very concretely about, especially about things that are still to be decided. So I think that's just to finish, to wrap it up. I'm teaching at ISDE for the last 12 years with a small interruption. I've built with Andrea Bossa the Master in Football Law of ITI. I teach in Austral, I teach in FIFA courses, and that's basically my background and my present occupancy.
Thank you
Hi,
so
everyone.
much for joining us today. And to the last but not least, please, Senor Barraco, to Daniel, do not tell me that, oh, you're only considering me as an old guy. Jesus Christ.
Well, it's tough speaking now to Michele and Dani, so I'll try to do my best. And it's a pleasure being here. So João, Pedro, and Fernando, it's again, thank you, and it's a real pleasure. If Dani is the more experienced one, then I'm probably the junior here. And as the junior, let's put it this way, I've been working for the past almost 15 years now in sports law. I've had my fair share of different hats and roles in my life. So I started out at Corinthians as a lawyer, then ended up moving overseas, came back, ended up at CBF, especially as an NDRC judge, so pretty much Michele, but in domestic cases. Then ended up becoming one of the FIFA mediators on the first list of mediators, which was quite an experience. At the same time that I became a FIFA mediator, I also ended up at the CAS list with Dani, which has been quite a pleasure and quite a ride so far. So after that, in May last year, basically when I finished my PhD, I ended up as the first person responsible for the FIFA Legal Research Hub as a FIFA legal researcher. And it's been a challenge, as Dani has said. It's been fun for me as I'm the academic one. That's possibly the closest thing that I can say that I identify with when it comes to my professional life, is I'm more an academic than a lawyer. And it has been quite an interesting position to be at and quite a challenging position to be at. So that's basically it. So thank you guys.
So guys, thank all of you for the introduction, and let's move on to the blocks, and this is our intention. And I'm just gonna let you know a little bit about the scope of this block, and I'm gonna straight to you, Roberto and Daniel, the appeal system of CAS, and I'll leave with Mr. Colucci. I'll start with him, basically how the FIFA tribunal is structured right now. What is this picture, and the main things, main elements that we had during those, I would say, the last year. We had many changes. So I'm going to start with you, Dr. Colucci, and then we move on to Daniel and to Roberto. So, Mr. Colucci, what is my intention right now is, as you know, as we were talking about, we had a big change in the scope of, we have a few chambers, right, few different chambers right now in FIFA. You have the agents chamber, you have the, the dispute chamber. So if you could give us, to all of our, audience, what is your, a kind of a overview about how the FIFA tribunal is structured right now, and those changes that we faced among the past year. So I'll leave the word to you. You have, let's say, probably around 4 minutes, between 4 and 5 minutes, to give us your point of view.
Okay. Roy, thank you so much for this. So, as I told you, I'm not that old, but I think I'm for sure the pioneer in the FIFA dispute resolution, which gives me the opportunity to explain you a little bit the genesis of the FIFA dispute resolution and also the evolution of the dispute resolutions. And I will try to give you already some practical insights as a member of the dispute resolution chamber. First of all, you are all aware that the FIFA dispute resolution, only the dispute resolution chamber at that time was established as a paritatic body composed of an equal number of representatives from players and clubs. This is also the definition that you find in the FIFA commentary in the few articles that have been written on the FIFA football dispute resolution chamber. Say that it is important for you to know that when we sit there as players representatives and clubs representatives, of course, we do not take the role of the lawyers of the clubs or of the players submitting their claims before the DRC. We are independent, we are impartial, but of course we have the responsibility to put on the table those elements that, for instance, the players face in the context of an international disputes, and of course also the other side of the table, my colleagues sitting as clubs there as representatives of the clubs, try to put the club's perspective in the disputes that we decide. But we do not play the role of the lawyers. The sort of a dispute is left in the hands of the lawyers, in the capacity that they have to put forward claims that are clear, factual, clear, precise, and transparent. During the years, I look at the clock, during the years, I saw a huge evolution in the dispute resolution chamber, in the sense that you have to imagine that until 10 years ago, more or less, we judges at the FIFA dispute resolution chamber decided the case only, watch out, on the basis of a summary of 1.5 pages prepared by the FIFA administrations. We did not receive the documents, the claims, the replies, and so on. And you know what does it mean to judge a case on the basis of a summary of 1.5 pages? If I give you guys, I see 6 of you now on the screen, if I give you some facts to summarize, be sure that you can come with 6 different summaries. What is important for Joao does not necessarily is important for Pedro. And this could lead to mistakes. During the last year, I have to say, thanks to the current FIFA administration, the incredible job that Emilio Garcia, Jan, Erika have done during this year, you can be sure that we, finally, we receive all the documents, all of them, on file. We receive, of course, also summaries made by the case center. The FIFA administration help us in doing this, referring to all the documents. But be sure that when we take a decision now, since already a few years now, we pass a decision on the basis of the documents that we receive ahead of our meetings. And don't take it for granted. This was not true until some years ago, which was, I think, a shame. But this was the way it was done. The system has been completely changed. So for the sports lawyers watching us, I can say only this. Provide, of course, all the relevant evidence. And please, do not come with long 200 pages claims. Because very luckily, your dispute is going to be judged in the same meeting with other 20 disputes. And we receive an amount of claims, thousands of disputes per year, thousands of pages to read. But we have also the responsibility to deliver fast. The figures are there. The average now of our decision is 6 months, and we come with the decision. So the message to all the sports lawyers there, at least at the stage of the FIFA dispute resolution chamber, focus on the evidence, but be concise on the facts, on even the legal reasoning that you may produce. Then you can have fun at CAS. And at CAS level, you can write whatever you want, all the pages you want. The CAS arbitrators will have, I'm sure that Daniele and Roberto will come with this, and maybe they will have even the opportunity to hear the parties, things that we do not have at FIFA. It's just a written procedure. And I stop it here.
Perfect, Ms. Colucci. Very insightful and the explanation. And, you know, I have things that I didn't know in the past about the documents that you mentioned.
I know.
And this is yeah. So I'm gonna join the issue that you approach it and bring the conversation with Daniel. And Daniel, this is an important thing that Professor Colucci mentioned about the documents and evidence, because I'm going to bring to you, when I started in CAS just a few years in the past, I had some difficulty because, just giving to you my background, I was a former lawyer of a law firm here in Rio, and we've been, holding a lot of labor cases since 20 years. And if we bring, for example, the concept of the Brazilian civil procedure in terms of evidence, we have a restriction. We bring the evidence with the initial petition, and as the time that we have the first level decision, no new evidence. I have a kind of a limitation of bringing new facts. I'm restricted to the facts that were mentioned in the initial petition. But I see in CAS just a little bit different picture. It seems to me this more open field in terms of production of new evidence. And I was trying to catch up from the memory once I had the professor, and he mentioned this point to me, and this was clear in my mind, and it was fixed. You have a new proceeding in CAS. So if you have a disfavorable decision by the FIFA tribunal, don't worry. You can look for new evidence. You can bring, even witness to bring for the hearing in CAS. And I found, and I got into the conclusion that this was the system totally different from the system, the legal system that we have in Brazil. So giving the word to you, how it is in your mind, this conflict of rules between our civil procedure here in Brazil and this open field in terms of appeal that we have in CAS. So I'll leave the floor to you. I think you're on mute.
I'm sorry. Now, okay? Okay.
Okay.
So thanks, Michele and João, for you gave me the ball, and we've been discussing, me and Roberto and Vitor Butrussi, about this every and each time that we meet each other in a bar or in a seminar. So first of all, I just like to add to Michele, if I may, Michele, that it was even worse than that 20 years ago, because we didn't have even the people that prepared that small synthesis of one page were not even people with legal formation as lawyers, or they didn't even come from law schools. That's for sure. I'm just stating the facts. So I will second Michele on saying that FIFA increased a lot the speedness and the specialization and all the giving the structure for the judges that are from many places in the world. They are not seated there. It's not a standing committee. We speak a standing committee. It is the player status committee that, as Michele said, take cares, gather all the documents. There's the handle the case like a secretary, if we speak like, if we imagine a Brazilian ordinary court, okay? So that's what would happen in a standing committee. But when Michele goes to rule the case, then he receives everything today, and it was not like this in the past, and that impacts the quality of the decisions, in my point of view. Also, I think we have to applaud that now. Everybody, and Ariel Reck used to say that there was a nickname for the FIFA loan. When you would, like, as a lawyer, to make up planning how to attack the financial difficulties of a Brazilian club, in the past, you always say, okay, you don't pay any international debt because it's 5% a year, and they take a long time to judge, to rule it. Now it's inverted the thing. So we say now, not only it's like a horse running, if you compare to the ordinary courts or even the DRC in Brazil at this moment, but also because you have the transfer ban. So there was not only procedural, but material changes in the FIFA broader approach on this that I think they are very positive. That being said, João, you said something that I'll take as a provocation. I know it was not, but when you said that you consider that the appeal before the CAS is a new procedure, and I tend to agree that it is a new procedure or it is another stage of a procedure. What you cannot say is that is a new litigation, because it is not. An appeal is an appeal. The litis, the dispute, it is the same. And in the past, I think we don't have this interpretation anymore, but I faced that as a lawyer. If you remember the case involving Fluminense, Flamengo, and Portuguesa, back there, when there was a risk of Flamengo or Fluminense being relegated, Fluminense was accepted. And then there we're speaking about a 4-stage jurisdictional procedure, huh? Disciplinary commission in Brazil, the court, the sport justice court, STJD in Brazil. Then the third instance would be the CAS. And Fluminense was accepted as a third interested party, which evidently was in Brazil in the 2 stages previous to the CAS. And then there was a ruling, a preliminary ruling, that it did not accept it, in my point of view, entirely wrong, did not accept Fluminense as a third party, although the success of Flamengo could lead Fluminense to the relegation. And that decision was based on, in my view, in my view, not the proper interpretation of Article 57 of the CAS Code. There is the key is in the Article 57. The Article 57 speaks about the scope of review of the panel. So the appeal arbitration in the CAS is something unique in the world. You cannot compare to the ordinary arbitration in commercial arbitration, orthodox arbitration, and you cannot compare to FIFA. Why? Why there is a wide scope of review? Exactly because it's more, let's put it this way, shy or humble. The production, the activity of producing evidence before FIFA, because it will be impossible, in my point of view, and it will be expensive, which is not today, if FIFA would open to long hearings as we have at the CAS with 8, 10, 12 hours of hearings. So you have a very narrow possibility of making evidence. That's why when it was designed, the appeal procedure before the CAS took that into consideration, in my point of view. That's why you can make all the evidence before the CAS. All of them depends. If you go to the third paragraph of Article 57, if you're speaking specifically, particularly about documents, written documents, of course, oral evidence, that will be the first moment where you can produce it. But evidence that should be documented, written evidence, you have to take care, because according to the third paragraph of Article 57, the same that speaks about the scope of review, says that it's under the discretion of the panel to allow or not to allow. I may say, as a lawyer and as an arbitrator, that in principle, but it's not a rule, if it is an important document and the panel doesn't feel that there was a bad faith by hiding this evidence, then I would tend to say that this evidence, in principle, is acceptable. Just to wrap it up, Article 57, if you can read that, says that the panel has the power to review entirely the facts and the law. But then there's the distinction that I pointed. You're not speaking about a new case, so you cannot innovate in the appeal procedure. That's something very important that, of course, as any appeal, even in the ordinary courts in Brazil, there are accessories that you can address, especially if you are the respondent. This is natural. This is kind of implicity and in the scope of your appeal. But you cannot innovate by asking for something entirely different from what you brought before FIFA.
Perfect, Daniel. Good explanation about the proceeding, how it is. And Roberto, I'll try to mix it up, the whole thing that we discussed with Daniel and Mr. Colucci with you. And then Daniel brought even financial sources here to explain a little bit how the FIFA was structured in a way that it was. But bringing this to you, is one of the things that I kept relying my thoughts. For example, there's some things that you let's bring some hypothetical situation. Okay, I have a player that is playing in Latvia, whatever, and he's being pressured to sign his termination with the club. This is not his intention, but you have also Brazilian players with him that are presenting that situation. So in many cases, I was even discussing with Fernando, with Pedro, we should bring this guy to FIFA, and then said, no, it's a kind of a unusual proceeding, unusual thing to bring a witness in FIFA. Essentially, as I can see, you have those, sometimes written declarations or something, but bringing this, processing all those information to you, what are the good things about, as Daniel said, it's not a new case, but if you, prove that you were not intentionally hiding documents, for example, because this is something strategic, all right? I'm going to hide something and I'm going to bring to the second level panel, how to prevent this kind of situation. And what is your point of view about this appeal system in CAS? I'll leave an open speech for you, Roberto.
John, that's a tough one. And let's see. It's whether anyone agrees or not, it's the CAS case law. It's actually the ECJ case law. It's the ECHR case law that CAS is deemed as the first independent body to decide a case. And that brings with it a pretty specific sense to the de novo review scope of CAS. And Danny mentioned that perfectly well. And Michele is one of the big names when it comes to that, like from the get-go. So everything that I learned when it comes to the first independent body to decide a case probably actually comes from Michele. And that means a couple of specific things. It's not a review that may encompass anything that the party wants to. So one of the things that Danny put out pretty well is that no evidence parties could have had access in good faith before it can be presented at CAS. The good faith part is the main issue at it. I think we're going to discuss it later, so I'm not going to delve into it too deep right now. But it has some other specificities. So first things first, the respondent at CAS cannot bring a counterclaim because of reformatic badges, which is something that is really important. And I've seen people forgetting it over and over again. Other than that, the issues that are the object of the appeal must have been the subjects of the appeal decision. So if Michele didn't decide that within the FIFA DRC decision, it cannot be appealed to CAS. That's also something that people tend to forget. The other thing that people tend to forget, but that's a little less common, is that the de novo review scope does not cover fees and costs regarding the appeal decision. So those, I think, are the three main things or three main restrictions when it comes to the de novo review scope. Other than that, when it comes specifically to the idea of written statements, you can file written statements at FIFA. It's more common to do it at CAS as well. And I've seen it happening in a couple of cases recently that some lawyers tend to use both the written statement and then later the hearing with the same witness. Sometimes that also helps out, even if we don't have the written statement at the FIFA level, simply because it helps guide the hearing a little bit easier, guiding the hearing a little bit easier for us, the arbitrators. And aside that, when it comes specifically to the de novo review scope, one of the main things that it's kind of, I wouldn't say a dogma, but it's kind of like a dogma, is that the CAS de novo review powers can cure any procedural flaws and basically anything else that happened during the first instance proceedings, which is kind of an idea that doesn't happen in practice, because as CAS arbitrators, we can either judge the merits of the case, but for us to judge the merits of the case, we must be sure that we can actually judge the merits of the case as a de novo review case. That is, it has, again, to have been part of the appeal decision. If it hasn't been in the merits of the appeal decision, we cannot judge the merits simply because there's no merits for us to judge. Or we can refer the case back to the FIFA, for instance. And if we do that, then it must be within the prayers of relief of the parties, because if it's not, it might hinder the positions of the arbitrators a little bit off when it comes to how to decide and how to deal with that specific case. So again, we can, as arbitrators at CAS, use the de novo review powers to do many things, but as Danny said, we cannot do everything. And as Michele said, it's really important for the FIFA proceedings to be done correctly and appropriately, so we can actually do our jobs if we have to do our jobs at CAS. So I think this is it. I think I answered the questions.
So thank you, Roberto. So I'm just try to summarize very quickly em português. Pessoal, a gente começou aqui pelo professor Colucci. O Colucci traz aqui uma realidade de 20 anos atrás da FIFA, que eu também não sabia, eu confesso que fiquei surpreso, né? Até vamos dizer assim, uma restrição na análise, né, em relação aos elementos, inclusive, do processo, porque ele diz que há algum tempo atrás sequer a documentação ela era disponibilizada, enfim, aos julgadores, né, o que traz para, enfim, para o jogador ali uma dificuldade muito grande. Ele sugere aqui muito menos complexidade no trato processual, no trato das peças. Eu acho que essa é uma tendência, Daniel e Roberto também imagino que também sigam essa linha, no judiciário como um todo, né? Eu estou dizendo aquele trabalho extenso do passado, aquele pessoal mais old school do direito. Eu vejo que hoje no direito a tendência é muito mais objetividade e menos narrativa, né? Então, o Michele trouxe essa radiografia. O Daniel, eu fiz até uma provocação que dizendo da minha, no princípio, quando comecei a advogar nesse segmento, né, a gente vem com aquela linha do processo civil brasileiro, né, aquela produção probatória até o primeiro grau de jurisdição, e depois você não traz nenhuma outra evidência para o segundo grau, a não ser que seja algum fato novo, né, e o CAS funciona um pouco diferente. O Daniel diverge um pouquinho sobre o fato de ser um novo procedimento, porque não é um novo procedimento, mas certamente a apelação para o CAIS ela tem uma característica, vamos dizer assim, uma amplitude probatória maior do que há na FIFA, e o Daniel trouxe um dado até econômico, né? Parece que não era muito interesse, não é da FIFA abrir muito em termos de produção probatória, né? Porque isso vai dar ao procedimento também uma complexidade maior, custos envolvidos com árbitros, etc, etc. E o Roberto também vem ratificando essa tendência, né? Ele hoje fala, o Barraco fala muito sobre um procedimento menos complexo, inclusive também na FIFA, né? E fala também falou sobre custos, né? Sobre produção probatória também no CAIS hoje em dia. Vou me permitir que fazer só um complemento, né? Se não tem ali a parte não é beneficiária do financial aid, realmente a produção probatória, se ouvir testemunhos no CAIS, você tem um custo muito maior do que se tem na prática. So guys, so this was the first block, and I'll pass the bar to Fernando. So Fernando will conduct the second one, and Pedro will catch up, and then we close the panel. So Fernando, all the words to you.
All right. So moving on, I'd like to explore a topic that it's very close to our daily legal practice as a point of view of a lawyer. So it will be really good to see a point of view as a lawyer from Daniel, and then his point of view as an arbitrator. Because as Michele mentioned to us here, it was possible to see that under FIFA regulations, especially on the procedure rules, one thing that I would like to know more about the witness statement, and in some specific and exceptional situations, the panel who will decide that case perhaps will request an oral hearing. In your point of view, Daniel, when you were a lawyer, have you seen that happening? And Michele, the same for you as a point of view as a DRC member. Have you seen anyone request for that relief? This is my first question, just to start it, and
Can you say it again? I'm sorry. Can you say it again? The question?
Yes, on the procedure rules of FIFA, it's specific, I think, in the article 14, I guess, that the written submissions is the evidence will be produced by the written submissions, but in exceptional matters, it will allow, if a party requests that, it will allow them to take place of a hearing during the procedure at FIFA background. So I would like to know if you have faced that before, when you were a lawyer working in that case, in a specific case that you request that it was one of your pray for relief. And in a point of view as a DRC member, Michele, if you have seen that happening or that never happened before.
Listen, it never happened. 23 years of history of the dispute resolution chamber, it never happened. You have to imagine that so in 23 years of experience at the DRC, I think there was only 3-4 maximum oral hearings. The one that I certainly recall is regarding the French player Mexes going from Auxerre to AS Roma. It was one of the first delicate cases, and only there at that occasion the FIFA allowed a kneeling. Forget that now you can ask it, but FIFA will not give it. It's just a written procedure now. So you can produce, of course, the written the testimony in writing of a witness, but it will never be heard at the occasion of a hearing, simply because there will be no hearing. This must be clear to all of you.
Perfect, Dr. Michele.
At FIFA level.
Yeah,
FIFA
for
level.
sure, for sure.
Listen.
Yeah, I would like to hear from you, Daniel.
Yeah. No, the thing is, I think FIFA, it's more open to hold hearings when you're speaking about disciplinary cases. So especially if you have, for instance, you have Messi, you have other hearings, because then you're speaking about discipline. And then I think it's not a commercial dispute. I know that employment related disputes are also very important, because we're speaking about the player's right, what he earns to live, to support his family. But disciplinary is a cousin of sanction. It's a species of gender of sanctionatory law. So I think that FIFA cares more if there are grounded requests for hearing. Then you can see that in the procedures under the responsibility of the disciplinary committee and the appeal committee, then you can have some hearings. I had the possibility to work, and I think that people that work with sports law, at many of you that are joining us now, you know that we are in a field that you have what we can call the sports law, more strictly speaking, that the rules that are brought by the international federations, the CAS codes, the WADA code, and so on. This would be like a vertical approach on sports law, but also we are in a field that attracts many in very important orthodox areas of law. So the economic rights were one of these areas where you have a mix of prohibitions coming from the system that changed with the time, with the ban. Before was just banning the third party interference, then the third party ownership was banned, and then you have all this asset that was economic rights mixing with regulations, with Swiss law in the end, that you apply in the end if you were speaking about a FIFA jurisdiction and especially CAS jurisdiction. So in all of this, I was a very privileged witness in the case of Ronaldinho Gaúcho, and we don't have time to go further on this, but actually what happened, Michele, I don't know if you know that, and then we can speak about this later when we meet, because it's a rich story. When the Bosman case led to the change of the regulations in 2001 of FIFA, in Brazil we had the same with Lei Pelé law. But the clubs made a huge effort, and they were much more powerful than the athletes, and they were given a vacatio legis of 6 months for Article 28, I think. Roberto must know, 28. And that part was exactly, Article 28 was exactly what was bringing the lessons from the Bosman to Brazilian law, which means no passe anymore, no retain and transfer anymore, and the sports bound became accessory to the employment-related relationship between the parties. So what happens that Grêmio played really well in that gap, and also PSG, because PSG saw, listen, if I put this guy on a plane, this is an international dispute. We're going to dispute before FIFA. And Grêmio on his hand and say, the only thing I can do is fight with the Brazilian law that protects the retain and transfer for me. And what many people doesn't know is that Grêmio won the case before the labor court in Porto Alegre. And with all these things, I was the lawyer of the investor that has 10% of the economic rights of Ronaldinho. And this is good, João, for you. We have to know what tools we have and the limits of efficacy of every and each rule and jurisdiction. We were granted, we asked for, because Grêmio denied us. We said to Grêmio, listen, you are saying that PSG stole your player, which was not entirely accurate due to the change of the law. But still, and then we said, listen, you are saying that, and we are pointing the finger because you already advanced that you're not going to pay me when I invested you to keep this player. So we should go with arms together, and you're forcing me. And we've done that. We were granted with an injunction in Porto Alegre by a state judge that obliges Grêmio to include us as lawyers of the investor within the team of Grêmio. So I went to the 2 hearings, very unusual cases before FIFA. There were 2 hearings to discuss, and in the end, the solution not to broke the system, because FIFA could not grant Grêmio any money under the heading of transfer fee, because otherwise it would be denying everything that they agreed with the European Commission, with UEFA in that meeting. So it was created the payment under the heading of training compensation, which was not like today. And that was crazy for you, Michele, if you were there already, because Michele, as a judge in FIFA, would receive papers translated from in Arabic, proving that the player was playing in such club, match reports. So it was different. There was no pre-established amounts and so on. So that was one of the only cases that I've heard before the DRC, actually before the Player Status Committee.
Thank you so much, Daniel. And what about you, Roberto? Have you seen any case related to that?
No, definitely not. When it comes to evidence, though, and if I may dive a little bit deeper into the topics that I was saying before, when it comes to the review, you have to be mindful of a couple of other tricks that are actually really complicated when it comes to gas. So first things first, Daniel was saying before that the actuaries have the discretion to exclude the evidence that is specifically if the evidence was available or could have reasonably been discovered by the parties in the first proceedings. Other than that, is also we have to be mindful of the duty of cooperations of the parties within CAS proceedings every single time, and that is really important when it comes to evidence, simply because the parties have a duty of cooperation to disclose any evidence that they have at their disposal in their custody or that are under its or their control when they have it. But it's the burden of proof of the party that wants to see those documents or that evidence to prove that that evidence actually exists and that is relevant to the case. And that can actually be something that might come up during a hearing, especially if someone wants to hear someone else during that hearing. So relevancy of the witness, and if the witness, for instance, was likely in some sense to actually know about the case at least. And that also is something that we need to be mindful when it comes to expert opinions, which is something that I should have mentioned before, but we can also have expert opinions in statements. So when it comes to FIFA proceedings, it's also useful sometimes to use those expert witnesses. Other than that, because of the duty of cooperation, if a party that has that evidence in its custody or under its control, and that party does not cooperate with the panel can make an adverse inference. That is, the party can basically say, oh, you had the duty of cooperation, so the other party is alleviated from its burden of proving that specific fact, because I'm going to consider that whatever the other party said is actually true, because you didn't provide the evidence that is under your control. Other than that, one of the things, and that mix again with what Danny said, that is actually really interesting, it's that happens if we're talking about parties in a specific case. So a case panel cannot order a third party that is not within the case to produce any evidence, other than sometimes FIFA is able to submit the case file, but other than that, no third parties. That is specifically interesting and tough when we are dealing with cases, like Danny mentioned, that deal with people that are not within the FIFA or the CAS system. And then we have to rely with the judiciary system of a country. It is tough, but it's something we have to be mindful about. Other than that, just like a couple 4 topics that are interesting when it comes to evidence is that when it comes to contracts, you have to provide evidence to ascertain to the true and common intention of the parties. So for instance, and I think that also dives into what you all mentioned in the first part. That is, if you are talking about a document that you are trying to prove that it's a fraud, it's a forgery, or if it exists or if it's valid, you can supply forms of communication between the parties to prove that what the parties actually meant, or that was actually what the parties did not mean to do. And that can be a WhatsApp conversation, that can be emails, that can be anything that might be filed in a proceedings. Other than that, and that's something that is really, 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 really common, that whenever you cite a domestic law, and that is the same for FIFA and CAS, please provide evidence of the actual law. It's your burden of proving that that law exists and that law says whatever it says. Other than that, specifically when you want to provide new evidence or file new evidence, keep in mind that you have to take into account the exceptional circumstances. And the exceptional circumstances clause is really important for us arbitrators because it's a procedural safeguard. So the panel has to allow that the parties file a new evidence within the exceptional circumstances, or the parties have to agree that one of the parties can actually produce that evidence. Otherwise, that can be an issue that is going to complicate things even after the case award. And other than that, if you're requesting for a specific for evidence production, be as specific as you can, because you need to specify a document. If you simply state or request that a party produce any evidence available regarding a specific relationship, then it's likely that the arbitrators are going to say no, simply because they're going to consider that to be overly broad and akin to a fishing expedition, which is something that is generally not allowed. I think that's it on my end.
Okay, very good. I think we covered, I wouldn't say the whole thing because we have many, many other issues to cover, but with you, I think Fernando wants to say something.
It's Daniel, I guess.
I just
sorry.
wanted to bring one. I hope that Michele doesn't get mad at me, but I do without a moral reserve, or no. I'm doing like seated as a judge too. Okay. Not bringing anything from somebody that you think could add to the procedure is the worst scenario. So you don't bring anything. You are not allowed to hear him before in an oral hearing before FIFA. Then, so you don't have it. So the only or the usual way to provide something is in written, a statement. And I wonder, and don't kill me now, Michele, but I'm doing that in good faith because I think as a judge, you are attached to the system. But I'm sure that as a judge in a proper system that would not give you 20 cases to judge in a date, you would rather listen to the witness.
Of course.
For you as a judge,
Sure.
of course.
And
So why haven't I seen, and I've done that since 15 years at least. And as far as I know, please correct me if I'm wrong. Why the hell the lawyers keep not providing with links, with statements or videos? Why? This is not very common. This is something, of course, is not the same of submitting a witness or a party to be examined and cross-examined and asked by the panel or you as a lawyer. But come on, between a dead piece of paper that doesn't sweat, that doesn't have any emotion showing, if you have a client, it is a party or is a witness that you think that is compelling and it's telling the truth, why don't you make a video and put in a WeTransfer or YouTube? Why? Because I haven't seen that. Please correct me, Michele, if this is a very usual tool. I don't see that anymore.
You are right.
It's the case that we never have that.
You are right. I tell you what we see at FIFA submission where we have videos made by players themselves when they are relegated in training fields in Siberia or in the middle of the desert. And then I come here to the burden of proof, which was also touched upon by Roberto. They own their own initiatives. They record these videos, okay? And they are, let's say, smart enough to produce these videos upon their own initiatives. But it's true, I never saw. This does not mean that maybe someone did it. But in my cases, I never saw someone, a lawyer, submitting a video about a witness giving it. I never saw it. I don't know why they didn't. So, but this maybe, Daniel, you give me also the opportunity to underline also this. We should not forget that the nature of there is a huge difference in nature between the DRC and CAS. The DRC still remains an internal, I would say, quasi-judicial body internal to the FIFA. Gives the decisions, but of course they are not the awards of a pure and real arbitration body like it is the CAS, with all the consequences, for the collection of the evidence, for the lack of any hearing, but just because they are different in nature, and maybe they also differ, for sure from a procedural point of view, but also on the need to provide decision as fast as possible, with all the consequences of the case, of course.
But I promise the last comment. But Michele, come on. It is amazing that a Brazilian player that comes back to Brazil after not receiving 6 months of salary, and we're speaking about any other country, like $2,000 a month, not $2 million a month.
Yes.
And he comes back and have FIFA with almost zero cost. It is amazing. We have to improve. Okay, we always have to improve everything. But come on, this is good enough for what is being offered. That's what I'm saying about I'm a fan of the FIFA jurisdiction in general, with all the limitations that has to exist, because it would be impossible to hold hearings like we have at the CAS.
Yes, absolutely.
And then this is one, interesting field that you mentioned, Daniel, because I give this example here in my daily routine. For example, I have the same complexity of filing a labor case here in Brazil and then submitting a claim to FIFA. So nowadays, everything is, we have the technology behind, so there's no complexity. And I agree, definitely agree with you. So I'm gonna catch up real quick in Portuguese. E começando um pouco do final, talvez eu acho que a parte mais significativa dessa nossa exposição tenha sido essa dica, né, que é esse nosso propósito do painel, quando o Daniel traz aqui, porque qual é a essência do que foi discutido? Uma possível limitação da produção probatória no Tribunal da FIFA e uma amplitude maior de produção probatória no CAIS. E o Daniel, inclusive, até como forma de vencer um pouco essa barreira da limitação, ele traz sugestões aqui, como, por exemplo, um depoimento gravado, é uma outra alternativa que a gente tem para poder fazer essa produção probatória. O professor Colucci também colocou que em 23 anos, ele com a experiência dele, ele teve 3 ou 4 oitivas de testemunhas e partes ali no máximo ao longo dessa experiência. Ele diz também, e me parece que essa é uma opinião em conjunto com o Daniel, que na verdade o cabimento da oitiva ela está muito mais atrelada às questões disciplinares, né, do que propriamente questões econômicas, né, relativas à disputas contratuais. Eu não tenho como sintetizar, mas talvez isso para o futuro, Daniel, a gente faça só um painel sobre o caso do Ronaldinho Gaúcho, para te deixar contar ali com todos os detalhes, enfim, para a gente poder se inteirar sobre ele. E o Barraco traz um ponto aqui, para a gente também não perder muito tempo, que me pareceu um ponto muito importante em relação a um possível auxílio nessa produção probatória de quem não é jurisdicionado, né? Então você tem um procedimento de alguém que não seja jurisdicionado pela FIFA, e o Barraco traz aqui algumas alternativas para a gente poder vencer um pouco, pular esse muro, né? E talvez vencer essa barreira para, enfim, aí empregar no procedimento um espírito de cooperação, não só das autoridades locais, como também o Tribunal da FIFA. So, guys, focusing on the last one, I promise to you that we are not taking over than 1 hour and a half, because that's too much. And we know all the effort that Professor Colucci put in this panel. He was in Madrid yesterday, so he was telling us all the challenge that he faced to get home today. And so we're not gonna, over limit the time.
No, you know what? You are sorry, I speak as Italian. It's so beautiful to listen to all of you in this beautiful, sweet language. I would say meu coração é brasileiro. It's incredible. I mean, I could listen to you for 24 hours in a row. Please, so don't worry about me. It's beautiful.
Vou falar em português, então, dessa vez, para passar a palavra ao Pedro, professor Colucci, até para o Pedro conduzir esse último painel e já caminhar também, deixar a oportunidade para vocês falarem em razões finais. Pedro, fica à vontade.
First of all, I have to switch to English again, unfortunately. It's my first interaction in the panel, so I would like also to thank you, Daniel, to thank you, Professor Michele, to thank you, Roberto. And then also, as João mentioned, we are coming to the end, unfortunately, but I would like to address 2 final questions to all of you. And then also you can present your final thoughts about the panel or anything else you want to raise. First of all, something regarding a question that Roberto addressed. He mentioned the experts evidence that you can produce before FIFA, and this brought me attention because some time ago I spoke with a player, and he played for 1 year in Croatia and received only 1 salary. So at the end, he was coming back to Brazil, and he was forced to sign a contract saying that he wouldn't claim anymore any kinds of salaries before any kind of tribunal, FIFA court, CAS, or any other national tribunal. So in this kind of case, how do you present this expert's opinion or evidence attesting that it's a document that was frauded? And how, with this narrow possibility of producing evidence, you can attest that this document is not a real document, that it's an unilateral document signed by the club in behalf of the player. And also, before passing the words to our guests, I will also make the other question that is related to the agents, because we now, since some months, we have the new regulations, but we don't have yet the chamber fully operational before FIFA. So regarding the issues related to agents, you have CAS, that's always an option, but we all know that not every agent can afford a proceeding before CAS, especially when the commissions are not so huge. So at the moment, the option of litigations on FIFA are limited, and CAS represents an expensive alternative. So regarding agents, what strategies, what advice can we provide to this class when they need to claim their commissions? So I'm gonna pass first the word to Roberto, and then on to Michele and Daniel.
Yeah, definitely. Let's see. So when it comes to evidence, either at CAS or FIFA, but specifically at FIFA, because you have less room to produce evidence. Let's say that we're talking about forgery, and I'm talking about what I have seen in different cases, not my personal opinion, and definitely not FIFA's opinion. When it comes to forgery, one of the things that I've seen happening is written expert opinions. That's one possibility. It's pretty rare at the FIFA Football Tribunal. It's more common within the FIFA judicial bodies. Other than written expert opinions, you can play with the standard of proof of comfortable satisfaction at both FIFA and CAS by providing, for instance, other documents signed by the player, by the coach, to showcase difference in signatures. Specifically to provide that there is kind of a room for doubt that the player or the coach actually signed that. Other than that, if we're talking about different interpretation more than forgery, or which sometimes might be some fraud, maybe, we can talk about emails, WhatsApp messages, or even written witness statements that say or state the context in which the player signed the contract that the player didn't want to sign. But the important thing is that the player or the coach must have confronted, at least at some point, the club, saying that he or she did not agree with the contract, with the clauses in the contract or something. Because if he or she stayed in silence the whole time and simply agreed, signed it, or even if he or she did not sign it, but did not say anything, it's tougher to provide any evidence simply because the player or the coach remained silent, which is obvious when I say it, but again, it's something that I've seen happening.
So, Michele, feel free to...
Yeah. Two things, because Pedro, I'm not sure that you referred, when you mentioned the case of the Brazilian player going to Croatia, then he had 1 month outstanding salary. He went back to Brazil. He was forced to sign an agreement or something.
He just...
This is, I think, a waiver. He signed a waiver. He waived to this outstanding amounts of money. Okay. And here I get very emotional. I get very Italian. Because I tell you, this is something that makes me mad at FIFA, and my colleagues at FIFA, they know it. I tell you. We have cases around the world where players at a certain moment bring their cases before FIFA with agreements on the basis of which they waive 6 months' salaries. 6 months. Can you imagine you are the player, you waive 6 months for what? You waive 6 months of the work you already have done. For what? There could be some exceptional cases of 1 month or 2 months when you want to facilitate the transfer of a player from a previous club to another one. But sorry, there is no logic for me to waive 6 months salaries for the work already carried out. In FIFA, we speak about a waiver written under duress. And this is, speaking about the evidence, this is one of the most difficult things to prove. The signature under duress. Because, watch out, I remember out of my experience, these are cases that I decided at the FIFA. Players, Italian players in Bulgaria with the Bulgarian clubs, called upon the president of the club in the room, a gun on the table, signed this agreement. How could the player prove that there was a gun there? Could it take a picture? No, it was really, really impossible. In all my cases, that I just noticed a smart move of a player. He played with the language. He was a French player, and it was an African but English-speaking club. Next to his signature, he put in French the words "under duress." But he was smart enough to do it. But not all the other players are able to do it, or under threatening, they do not think about this. So you see, there is the forgery issue, which is something, and I tell you more and more in FIFA now, we are happy to see, if an act is blatantly forged, we recognize immediately, or of course we rely also on the experience of on the experts. But one thing is the forgery, another thing is the waiver of agreements under duress. I repeat, one of the most difficult, quasi impossible things to prove. And I stop it here.
Thank you, Michele. Also, the guy you mentioned, he was smart enough to write in French, and lucky enough that the guy with the gun didn't speak French also. So I know it's a difficult situation. And also to go on and pass the word to Daniel, since Professor Michele and Professor Barraco already addressed my question regarding the experts' evidence. I would like Daniel to answer the one regarding the FIFA agent situation. If we can go on with this, Daniel.
The $1 million answer, and I don't have it. So, but may I address very quickly first what Michele said in the second round here, just to mention, we had some clients that were Brazilian coaches and assistant coaches training in Nigeria, and they were hired to be living in a region that was very reasonably safe in Nigeria, and the club changed its headquarters to Lagos, which is a very difficult city to live. They wanted to get rid of the assistant coach and all the team. So instead of the big house with 4 suites that they were granted in the beginning, and a chauffeur and a private security, they sent him to a hotel where they contracted malaria. There was and the players of this club became our clients too, and the food that was offered was radically changed also. And one night they followed the truck that would bring their food, and they were surprised somehow that the food was being caught by a place where animals were being fed. So this is real life for most of the players. We're not speaking about fancy lives and fancy contracts and fancy shoes. So this is the reality. And just not to lose the point that not Neymar, Nilmar was a great player from Inter, played in Corinthians, played in France. Nilmar was playing in Qatar, and he was able to be transferred to Inter after the transfer window was closed because they terminated unilaterally the contract with Nilmar and told him, listen, according to the contract, you are entitled to receive 3 months of salary. And there was this imbalance if it was the opposite situation where the player wanted to terminate without just cause. So he was not happy with that, and he told the club that he would challenge before FIFA to receive more than only 3 months. So he have done that. Internacional made the transfer because he was without contract, unilaterally. There was no discussion about that. But I'm not sure if you know that, Michele, but in Brazil, it's a kind of crazy because you also have the limitation in terms of deadline for every and each competition. And in Brazil, amazingly, we have 38 rounds because we are 20 clubs in the first division. And you were allowed to register a new player for the competition until the 34th round. 34th round. I don't know how you can balance that with the principle of integrity of competition. It doesn't matter. So in the end, when the club knew, the club made counting the days. You remember back there that there was 7 days to the answer. If the former federation didn't answer, the new one would still have to wait 7 more. So this case led to the changes in the regulations of FIFA because the club starts to count it and say, listen, if we don't answer Inter, it will lapse all the time and they will not able to register him, which was a coercion, clearly. But before FIFA, and we were supporting, because we are lawyers of the club, and Breno Tanuri was the lawyer of Nilmar. So the club says, you have to come here now and to waive not only everything that you wanted, but also the free salaries that I told I would pay you. So is it reasonable that a player that is training in Porto Alegre would stop his training sections, go to Qatar to waive something only because, of course, there was a duress in this case, and Breno, what he did, it's not a bulletproof tool, but he left the headquarters of the club and he went to the consulate or the embassy. And of course, this alone doesn't say too much, but if you put coherently with all the other things, it's not something that everyone goes to the embassy to make a kind of report. And then in the end, before FIFA, it seemed, if I'm not mistaken, Nilmar did not win the case before FIFA, but he won the case before the CAS. It's a very important case because there was some decisions there incidentally speaking about the gap that the regulations of the TMS back there provided the opportunity to the clubs using in bad faith the silence and the inaction. And the decision of the CAS was very interesting because it says, you don't have this time to answer, to use it with bad faith. If you have a reason to oppose to the international transfer certificate to be issued, you have to raise it at day 1. So that was a very important case, and that was exactly one about duress. I've done all of this so I don't have to answer about agents, but I'll still say something. It is difficult now, especially because since, as it happens in 2015, when there was this kind of deregulation, which I don't call it, I think it was a change of system from agent systems to intermediary systems. When that happens and FIFA ceases to have jurisdiction over these deals involving agents and then intermediaries, the clauses that existed in the contract signed previously that became somehow, they have a deficit of enforcement. Okay? So this is happening exactly the same right now. So you were relying as an agent in the system. Then there was this decision forced by an influx of a decision in Germany. And then from one day to the other, you don't have jurisdiction anymore. So what can you do now? And there were, and there are, I think, attempts to say that since FIFA is not competent anymore, you could go to CAS directly, which would mean that you would replace a quasi judicial procedure, as Michele said, and that provided for a way to the CAS in a specific procedure, which is an appeal. So I'm not sure. I don't, because it depends. Maybe as a CAS arbitrator, somebody brings an argument that you're not thinking. But I would incline to say, because it was said already in a case, that it's not exactly the same to say that the CAS is entitled to rule this case directly in an ordinary arbitration, particularly because you don't have an arbitrational clause when you provided by FIFA jurisdiction back there. So I would say that nowadays, if you don't have FIFA jurisdiction, probably you have to find something in the ordinary courts today. Okay, so I think that would be one of the big issues that are at the moment. And of course, if you have, I would say 100% that if your client is involved in a big deal, you should put CAS in an ordinary arbitration, because you can have the enforcement of FIFA 100%, not 100%. Because if FIFA is somehow, I would say in principle, obliged to enforce decisions made by the CAS in ordinary arbitration. However, if it's a decision that was granted, for instance, by the CAS in favor of a lawyer in an ordinary arbitration, and a lawyer is not part of the organized football, you cannot, in my point of view, provoke FIFA to enforce that. And the same is valid to the merits. There was a case that you can find, or I can provide you, where there was an agent and a club, but the deal was a loan of money. In an ordinary arbitration of the CAS, it was decided that the club should pay the agent. Although this kind of, I'm not even saying that it is prohibited by FIFA regulations, is just out of the scope of the relationship that FIFA designed for the agents and the club. So FIFA said, I'm not going to enforce that. So you have to take care about the subject. But if you're speaking specifically about commissions, purely agent club or agent player deals, I would go to the CAS if there's money involved in an ordinary arbitration.
Maravilha, ótimo. Professor Michele, eu vou me permitir falar esse finalzinho, até porque eu vi que você gosta muito de ouvir o português, então vou me permitir terminar em português e vou já dedicar vocês ali o tempinho para as razões finais. E talvez, Daniel, aproveitando o seu gancho, o Fernando também, que é um cara muito, vamos dizer assim, muito interessado nesses detalhes, né? A gente fez aqui agora, lembro recentemente, que era um painel do IBDD sobre mercados remotos para o agente, né? E aí trouxemos ali para falar um pouco sobre levar o jogador para a Indonésia, para o Paquistão. Eu me lembro quando já passei para o Fernando, a primeira coisa que ele perguntou, já comeu grilo, gafanhoto, né? Ele queria já os detalhes ali da história, então a gente para um futuro fazer um painel só com essa resenha bem própria ali das pessoas que viveram o mercado. Então, professor Colucci, começando por você, agora em português, você fica à vontade também, se quiser falar em italiano, português, inglês. Queria agradecer muito a você pelo seu tempo. Eu sei da correria que foi de ontem para hoje, você voltando para casa, e você sempre com aquele ar italiano trazendo alegria para o ambiente, né? Então, muito obrigado. Senti essa sua energia mais uma vez, já tinha tempo que eu não o encontrava virtualmente, mas foi muito bom. Muito obrigado pelo seu tempo.
Obrigado a todos. I'm so grateful and I'm so happy you have this, you are gifted because you spread the joy around the world with your smile, with your language, with your way of life. It's incredible. Thank you so much and congratulations because you did really a fantastic job. I'm so happy that I had the opportunity to meet you all again, Daniel, Professor Roberto Barracco, and all of you guys, and keep on doing this fantastic job. Obrigado, muito obrigado.
Muito obrigado, professor. Daniel, a você também, novamente, falei isso para você quando nós estivemos no CAIS ali no ano passado, né? Você é uma referência no Brasil e sempre te escutar nessa temática é um prazer enorme. E quer dizer, e além de você na sua pessoa, né? Você com toda essa qualidade em relação ao conteúdo, você ainda tem ao seu lado o Rogério e o Chico, então eu diria que a tropa de elite do direito esportivo brasileiro aí no Sul, né? O pessoal que está na linha de frente do direito esportivo, nessas transações internacionais. Meu abraço também ao Rogério, ao Chico. E muito obrigado, Daniel. Sei da sua correria e você dedicar o teu tempo para poder passar esse conhecimento para todo o público, para o IBDD, é de uma valia muito grande. Muito obrigado.
Não, João, Pedro, Fernando, agradeço imensamente. Eu não comentei antes aqui, mas eu, durante muito tempo, quando o IBDD, lá no seu começo, já tinha começado, né? Acho que não precisa referir todo mundo aqui, mas a gente sabe, né? O Beto, bom, todos que estavam ali, o Felipe, a Isabela, o Roberto Barraco vai me lembrar de todo mundo aí, senão eu vou acabar esquecendo. Santoro, tantos outros, né, que criaram o IBDD, e eu fui um colaborador do IBDD nos primeiros cursos, inclusive dando aula em São Paulo e em Porto Alegre. Então eu tenho um carinho muito grande pelo IBDD. Por outras circunstâncias, a gente acaba se afastando um pouco. Eu tenho a sorte ou a fortuna de ter sócios que realmente são fantásticos, assim, né? Com cada um com as suas valências dentro do escritório. Hoje por uma decisão, eu não tenho impedimento como advogado, eu pessoalmente, de advogar perante a FIFA, mas por uma decisão minha, eventualmente o fato de não haver audiência facilita muito, mas eu tenho procurado não atuar praticamente em nenhum caso, nem em termos de assessoramento dentro do escritório, para poder focar nessa função de árbitro do caso. Na área consultiva, continuo trabalhando na questão de contratos, planejamento. Perante a Comebol também, embora eu possa atuar como advogado, não tenho mais atuado, porque não há esse impedimento, mas me sinto mais confortável não atuando. E isso acaba sobrando mais ainda a responsabilidade para o Chico, para o Rogério, para os outros advogados lá, na medida em que o escritório também continua atuando perante o caso, né? Com situações bem separadas. E e é um prazer poder discutir nesse nível, né, com o Michele aqui, com o Roberto, com vocês três também. Estou sempre à disposição. Eu fico mais feliz, eu acho, por poder contribuído com algumas questões, talvez algumas dicas que eu vejo que são bem práticas, mas que podem mudar o rumo de um processo, sabe? Às vezes a gente discute coisas que têm muita densidade, o que é importante, mas existem coisas bem pequenas ali que às vezes pode fazer a diferença, né? Pode ver, pegando uma pessoa com a personalidade do Michele, Michele, I'm saying that if you face
No,
a
no, I
judge with
understood that. I
you
understood,
understand everything. Yeah. Então,
that's great.
dependendo, né, do a quem você quer convencer como advogado, né, um vídeo, se for realmente um vídeo convincente, né, numa situação dessas, né, numa questão de provar, por exemplo, que houve uma coação, né? Às vezes a palavra pode ser importante, não vai substituir uma presença testemunhal. Aliás, para finalizar, para quem vai fazer audiência no caso, nunca deixe de fazer audiência e de ouvir testemunha. Se der para ser presencial, presencial é muito melhor. Para todos, agora às vezes é caro, então não faz presencial. Mas só abre mão de ouvir testemunha se for prejudicial para os interesses do cliente ou se for totalmente irrelevante, senão é um pecado não ouvir testemunhas e as partes, às vezes, no caso. Obrigado.
Maravilha, ótimo, né? E Roberto, a você por final, né? Assim, a gente sabe que o tempo de maturação do profissional do advogado é diferente do jogador, né? O jogador ali com 30 anos já é um jogador experiente, né? O advogado, quando ele está chegando ali para os 40, né? Ele ainda é um advogado novo, né? Então, talvez eu não fizesse a comparação, trazendo aqui em relação a você, dissesse que você é o novo Neymar da arbitragem desportiva, do direito esportivo internacional, porque o Neymar acabou ficando velho, né? Mas então, talvez ali, falando um pouco de um outro jogador, o nosso novo Estevão, aí, vamos dizer assim, do nosso direito esportivo brasileiro, a arbitragem brasileira e internacional. Te agradecer também, sei dos seus afazeres ali, você dedicar também 1 hora e meia também do teu tempo, da tua tarde, para poder compartilhar com a gente conhecimento também é muito gratificante. Muito obrigado, Roberto.
Eu agradeço, João. É sempre um prazer, ainda mais poder estar aqui nesse painel que quando eu comecei, jamais ia imaginar que um dia eu ia estar aqui com o Dani e com o Michele. Então, para mim também é uma realização na carreira e pessoal. Se eu fosse pensar em alguns últimos recados, bem na linha do que o Dani falou, de coisas que a gente vê acontecendo e que eventualmente pode ajudar quem está começando ou quem quer repensar a sua maneira de fazer as coisas. Acho que na FIFA, um dos pontos mais essenciais é lembrar que o procedimento lá não é só um ensaio, ele é um procedimento. Nisso, faça o seu melhor. Eu já cansei de ver gente que simplesmente liga as saudações no procedimento FIFA e não faz nada. Foca nos fatos, não necessariamente nos direitos, nos fatos, que lá é o ponto mais importante, é o que de fato eles vão olhar. E, além disso, usa os documentos como prova desde o começo. Também já cansei de ver gente só esperando para juntar depois. Não, usa lá. Já no CAIS, primeiro, lembrando que o Michele já falou, o Dani já falou, seja conciso. 90 páginas é muita coisa. Ninguém vai lembrar, mesmo que leia as 90 páginas para a audiência. Então, seja conciso, mas usa prova e faz referência a essas provas no que você escrever, porque é isso que vai fazer a diferença na hora da audiência. E, mais do que isso, nunca pense que você vai conseguir provar um fato de uma maneira implícita, porque prova é sempre de maneira explícita. E a última coisa, que acho que é o maior desafio que eu tenho visto hoje, está sendo até uma brincadeira, Michele, I'm sure you saw that happening at least once, usa jurisprudência de verdade. Ou seja, se você usar IA, olha o texto, vê a jurisprudência e tenha certeza que aquela jurisprudência que você citou é de fato a jurisprudência correta e que ela existe. Porque isso está virando um inferno no dia a dia, não só do ponto de vista da administração, como do ponto de vista dos árbitros. Acho que é isso. Obrigadão, gente.
Agora tá fácil com o trabalho do Barraco lá na FIFA, tá fácil de acessar a jurisprudência.
Pois é, é verdade. Então, vou só para terminar, eu já vou passar na sequência para o Fernando e para o Pedro. Daí, Pedro, o Fernando, você já fica à vontade para passar a bola para o Pedro, mas também, não menos relevante, destacar a importância de vocês dois. Eu já disse para você e para o Pedro, né? Talvez as duas grandes figuras ali, o pessoal naquela faixa ali abaixo dos 30, né? Ou próximo a isso, Fernando e o Pedro são duas referências ali, e a gente sabe da dificuldade que é o nervosismo que é da nossa parte montar um painel, agradar todo mundo, estruturar os blocos, né? E o Fernando e o Pedro foram pessoas decisivas. Então, para você, Fernando, meu muito obrigado. Deixar você também falar rapidamente suas considerações finais. Depois fica à vontade para passar para o Pedro e o painel está encerrado. Obrigado, gente. Fica à vontade, Fernando.
Olha, João, para falar bem a verdade, meu pai falou para mim uma vez na vida que a coisa mais valiosa que você pode receber de alguém é a atenção e também o tempo dela. E vocês, pessoal, nos deram isso. Para mim não teve coisa mais valiosa do que isso. Para mim não tem preço eu conseguir fazer esse painel juntando todos vocês de uma forma muito mais agradável. Para mim, como um eterno estudante, é um prazer imenso estar aqui com vocês, poder discutir sobre o direito esportivo internacional, o qual é a parte do direito que realmente eu mais gosto de discutir fatos, porque nem sempre o que a gente acha aqui no Brasil que é irrelevante na Austrália, por exemplo. E é isso que eu acho que tem um gostinho do que é o direito desportivo internacional, essa diferença que a gente tem de saber as culturas, como são diferentes e distintas. Então eu agradeço de coração em nome do IBDD por cada um que deixou o seu tempo tão valioso aqui conosco hoje. Eu sei que o Barraco já tem afazeres agora 5 horas, eu sei que vocês têm muitos afazeres, principalmente no meio da tarde. E professor Michele, thank you so much to attend this Congress. It was a pleasure to have you here with us. Tchau e muito
Tchau.
obrigado. Grazie, hermano,
Grazie.
amico.
Grazie.
E Pedrão, eu vou passar a palavra para você agora, para você fazer as considerações finais e a gente fechar esse painel.
Obrigado, Fernando. Eu anotei vários pontos aqui que eu poderia encerrar, mas eu não quero me estender muito também, porque senão ficaria meia hora aqui repetindo o que já foi falado, mas que bom que está gravado no YouTube e todo mundo pode rever quando quiser. Mas, enfim, agradecer novamente nossos convidados, tomando as palavras também do João e do Fernando. Acho que é redundante dizer aqui que foi muito enriquecedor, principalmente para a gente no papel de advogado aqui, como vocês falaram, diversas dicas valiosíssimas que a gente trouxe aqui para esse painel. E o objetivo do painel, não só do painel, mas do projeto que a gente está montando, como o João mencionou, no primeiro painel a gente trouxe a gente também para falar do mercado de transferências para mercados alternativos, né? É exatamente isso, você pegar esses insights que talvez em uma aula tradicional, um livro, ficaria ali naquela perspectiva mais introdutória ou de apresentação de normas gerais. A gente quer pegar ali a vivência e essas dicas ali que são detalhes, mas detalhes que mudam o caso, né? Então, agradecer novamente e já vou proceder aqui também com a parte operacional de encerrar a live do nosso YouTube. Então, já podem ficar à vontade para desconectar, que eu vou fazer a desconexão aqui, agradecendo também ao nosso público que esteve presente no YouTube. Tchau, tchau, pessoal.
Ciao, ciao, ciao.
Tchau.